Hey folks, Mike here with Martin Mike Properties, and I have a special guest for you guys today. I have Sevan. Sevan, would you please introduce yourself to our viewers?
Sure. My name is Sevan Gorginian. I'm a trusted bankruptcy attorney, and thank you very much for having me.
Absolutely. Actually, I was super excited that you wanted to do this interview with us, and I wrote down a lot of good questions because I want the viewers to get a lot of value out of this. So if you don't mind, I'm just going to go through my notes.
Absolutely.
Sevan, what are the primary benefits of creating a living trust as part of one's estate planning strategy, and how does that differ from a will?
Great question. So the main difference between, I want to start with the second question. The main difference between the trust and a will is a will still be subject to probate court.
Okay.
Because the probate judge needs to determine the authenticity of the signature and whether the witnesses were there. And a will become public. Okay, so the last thing you want is for your will and your private wishes to become public, for your snoopy family members saying, what did Mike have,
Sure. How much money you had in the bank?
Yeah, how much money did you have and who would you give it to? So you want to avoid that. The way you avoid it is the trust. The trust is a private document. It does not get submitted to probate court. And it's also something that you can't actually look up anywhere. So I can't go look up, like for myself, the Gorginian Trust and see what's in there. It's a private document. That's the main difference between them.
That makes a lot of sense.
Yeah.
So, Sevan, my next question is, how can a living trust help avoid probate, and what are the advantages of avoiding the probate process for the beneficiaries?
Okay, great question. So once a trust is established, that will automatically avoid probate.
Okay.
There are different ways also that you can avoid probate. It's not just through a trust. The goal about avoiding probate is if an asset has a beneficiary listed, it will not go through probate. So for example, your bank accounts, if you put a beneficiary like your kids on the bank account, that money will not go towards probate. The bank will just cut a check to your kids. There's also a deed that's can be recorded on a property that's called a debt transfer on death deed. Okay. It says, once I die, my property will be transferred to this person. Same thing with life insurance. Everything has beneficiaries. So that's how the probate process is avoided. And, I've said this many times to people. And I remember speaking somewhere and there was a probate judge in the crowd. And I always tell people probate is, I think, the biggest scam in America.
Really?
It's the biggest scam. It's a way they found a way to kind of take people's assets and make you pay for it. I mean, if you just think about it, let's say, God forbid, you pass away. Okay, I don't want to put an expiration on you, but if you pass away, your wife would think, okay, everything's mine, Unfortunately, that is not automatic. She would have to go to probate if you didn't have a trust. You would have to go to probate court and say, I'm the wife, here's a marriage certificate, please give me my husband's assets.
Correct.
They'll take, I'm just going to make up a number, $20,000 off the top and say, okay, here you go. That's a scam. Like, why do we do that? Why doesn't it automatically go to the kids? So that's why I always believe the probate court process is the biggest scam. It's something to be avoided.
Wow. Didn't expect to hear that from an attorney.
Actually,
Yeah.
So at the conference, the probate judge came up to me saying, oh, I'm Judge so-and-so. I'm a probate judge, and, it's not really a scam. And I said, do you guys take people's money and assets and then transfer it to their kids? Yes. I said, why do you need to do that? Well, that's how the laws are written. I said it's a scam, So he was not happy, but I think he knew it's a scam too.
Got it. All right, let's move on to the follow-up question is, how does the process of creating a living trust work, and what are some of the common mistakes people make when setting up their trust? Ooh, that's a good one.
Great question.
Sure, a lot of people make mistakes, right?
So there are a lot of mistakes made. The way the trust is set up through my office is very different from any other offices. I believe I have the most efficient and cost-effective way to do it. All I need is the photo IDs and a copy of the deed. So once we have that, I quickly can establish a trust scenario that will be the most beneficial to the client and their kids. We can have everything ready in about 72 hours, and then the client can come in and sign. Most of the time, clients are in a rush to get it set up because they're buying a property. They're like, well, I'm buying a property. I want it to go directly into the trust. We can have it ready before escrow closes, and escrow will deed it directly into the trust. So that's the process. We go through a very small questionnaire. I don't give a questionnaire to the clients because I want to make it simple. I don't, most other attorneys will say, here's a 20-page document, go fill it out. I don't do it like that. I'm trying to make it simple for people. The most biggest problem that people have when they create a trust is they don't what's called fund the trust.
Okay.
Think about the trust as nothing more than a box. Okay. So once you create a trust, imagine this imaginary box in front of me, like a suitcase. This suitcase does nothing if you don't put something inside it. That second part is important. Now you got to put your stuff inside this trust.
Okay.
We help you put your biggest asset, which is your house, into the trust. We tell you how to put your bank accounts in this trust. The goal is to avoid probate, get everything inside this box.
Okay.
Where I've seen recently, due to a lot of people refinancing in the last few years, is the bank will not lend to a trust. So the bank will say, you want to refinance, fine. So the I don't know if it's the loan officer or whoever, if someone has a trust, they transfer it back out of the trust into their own name,
Correct.
give the loan to the person. The next step is they have to transfer it back inside the trust. They don't do that second part.
They forget.
So they forget. So I tell clients, if you refinanced in the last 2 or 3 years, check the title. Make sure they put it back in the trust. Last thing you want is, 20, 30 years from now, you take the long dirt nap, you die. My mom hates that joke whenever I say that. So, but you pass away, your kids are going to be like, wait a minute, why do we have to go through probate? My parents had a trust. Well, in 2021, they refinanced. They didn't put it back.
Wow. That's a good point. I appreciate you sharing that with us.
Of course.
I think I got a good question for you, Sevan. How can a living trust be used as a tool for protecting assets from potential creditors, and what limitations exist in terms of asset protection?
Okay, great question. When you said I have a good question for you, I thought you will ask, how much do I weigh?
You're taller than me, so it makes me look like a midget right now.
This topic about asset protection is very important. I don't know where this myth started from, okay? But I can't tell you how many times a week I tell people a trust is not there to protect assets from creditors.
Really?
Right. It is.
I always thought that it's for that reason too.
No, it's not.
Tell me more.
There are some trusts that can do that.
Okay.
But the most common trust is a revocable living trust. The reason why it is not an asset protection device is, imagine, again, you have a suitcase, okay? You take your house and you put it inside your suitcase. If I were to sue you,
Okay.
you'll say, yes, Mike doesn't own any properties. Okay. Do you have a trust? Yes. Well, is it a revocable trust? Yes. Well, reach in there and pull out the house and give it to me.
No way.
Yes. If it's a revocable trust, you can still reach inside and grab those assets. So a trust is not there to protect assets. If you want asset protection, you need to hold the entity, you need to hold the properties in an entity like an LLC or a corporation. Second, it's also a good idea to have a sufficient insurance policy. I always recommend to get $1 million insurance policy. It's the cheapest form of asset protection. So it's not a good asset protection device.
Wow, I did not know that. I always thought that when you have a trust, you're fully protected. That's a separate entity. But
Right.
based on what you're telling us, there's more to it then.
Right. There's much more to it. And the way I explain to clients is, if it was that simple, we would not have a judicial process. It's, hey, I'm being sued, Sevan, create a trust, haha, American Express, you can't get it. So our court systems wouldn't work like that. Creditor action wouldn't work like that. Where it actually does protect against creditors is your beneficiaries, your kids, and their debts. So if your kids have credit card problems, your kids are listed as a beneficiary of your trust. They're going to get 50% of your trust assets. If they have credit card problems, there's a provision in the trust. It's called a spendthrift provision. I don't know what it means, but what it says is the beneficiaries' creditors cannot reach into your trust and say, well, your daughter's going to get, this $20,000, so we want to reach it. That is where the asset protection happens, but it's only for your beneficiaries.
Well said.
Thank you.
Okay.
I've said it many times. That's why it comes off naturally.
Yeah. All right, so I'm definitely enjoying this interview, and let's keep it going. I know some of the viewers are curious to know what else we got to cover. So, are there any specific legal or tax advantages to establishing different types of trusts, such as an irrevocable trust or a special needs trust, in addition to a living trust?
Yes. So, a irrevocable trust, I just want to get that out of the way. A revocable trust is when the trust can be, basically undone or changed.
Okay.
During your lifetime, you're allowed to make changes, take off the beneficiary, add an asset, etc. That's what makes it revocable. Irrevocable is you can't change it.
Okay.
Now, the difficulty with that is you also can't be in charge of that trust either.
What do you mean?
If you want that to be a asset protection device, going back to the previous question, is once I create this box and I put my house in there,
Okay.
if it's irrevocable, you can't change it anymore. The second step is where people mess up, is I also cannot be the owner of this box either. If I get sued, they could say, Sevan, you created irrevocable trust, so you have the keys to the box, open it and take the asset out. But if I name you as the trustee,
Okay.
and I get sued, it's, wait a minute, I am not the trustee of this irrevocable trust. It's Mike. So,
Makes sense.
and I can't force you to open that box.
I ain't opening no boxes then.
Right. So that is the irrevocable part. The question about the tax benefits is one of the second biggest reasons why people do a trust.
Okay.
The first one is to avoid probate. The tax reasons is number two. The biggest thing is the capital gain savings. So if you, I mean, obviously you know this, if you buy a house for 500,000, sell it for $1 million, you will pay a capital gains on the 500. And I know there's the whole marriage and exclusion, etc. But let's just say you earn 500, you're going to pay a capital gains tax on it. I'm going to make up a number of 30%.
Okay.
But if you put that same asset that you bought for 500,000 into your trust, and then it goes to your kids many years later, and now it's worth $3 million, that's a $2.5 million gain.
Sure.
When your kids get it out of the trust, they won't be paying capital gains on the $2.5 million because the property value would reset.
Correct.
They take it out of the trust and then they sell it.
Step up basis.
It's a step-up basis. Correct. So that's why it has to be better to be transferred through a trust. What people do is they're like, well, let me just add my kids to title.
They do that a lot.
Don't just add kids to title. You're basically waiving your rights to a lot of capital gains tax.
I tell my clients every day, I'm like, just put in the trust, take advantage of the step up basis. Because at the end of the day, you're still going to give to your kids anyway, so do it the right way.
Right. Exactly.
Okay, Sevan, let's go to our final question. In which situation might a living trust not be the most suitable estate planning solution, and what alternative options might be considered?
That's a great question. So not everybody needs a trust. Okay. So I've seen everyone trying to push trust onto people. Not everyone needs a trust. A classic one is my grandma. Okay. If you have assets less than $188,000, you don't need a trust. Okay. My grandma has no property. She has some cash in a bank account. She has some personal property. She doesn't need a trust. She could just do a will, and that will basically just say, I give everything to my kids equally. Okay. And then the kids will basically distribute. How do you get access to the bank account? So if my grandma has my mom listed on the bank account, my mom can go inside and take the money out and distribute it. We don't need the probate court process. So not everyone needs a trust. If you add beneficiaries to your assets, it will go to them. So you can add beneficiaries on your bank accounts. You can add beneficiaries on your vehicles, investment accounts, life insurance, etc. So those are other ways to avoid probate.
Perfect. I also heard, well, when we first connected, I'm like, wow, you sound very knowledgeable. You're very confident. And I heard you also teach at CSUN, huh?
I do. I go Matadors. I also teach at CSUN and at Glendale College. I love teaching. So
beautiful. I could tell the way you're explaining things. I could tell your passion's coming out. You want the viewers to be educated. So I appreciate you being out here.
Thank you.
Tell the viewers, how could they connect with you if they have any questions?
Sure. You guys can reach me at my office, 818-928-4445. You can visit my website, gorginianlaw.com. I did it myself using Wix. I'm pretty proud of it.
Spell that out. People are going to want to know how you
GORGINIANLAW.com.
Good.
Or you can follow me on Instagram, BK Trust Lawyer, and that's how you can find me.
Perfect. Sevan, well, I appreciate you being out here. Thank you so much. I hope the viewers found this valuable, and I'll be in touch.
Thank you very much. And congratulations to you and Martin. I wish you guys all the best.
Thank you very much. I appreciate that. See you guys.